Business law, obligations, I don't know what part is this. Alright? Payment by cession is a transfer of or assignment of all the insolvent debtor's properties to all his creditors, so that from the proceeds thereof the creditor may obtain payment of their credits. Its requisites are: there must be two or more creditors, the debtor is insolvent totally or partially, there must be consent from the creditors, all the leviable properties of the debtor are assigned to all his creditors, and the creditors will sell those properties. The distinctions between the shonen payment and the payment by cession are: the shonen payment, there is only one creditor. Payment by cession, there are two or more creditors. The shonen payment, ownership of the property is transferred to the creditor. Payment by cession, properties are only assigned to the creditors. The shonen payment, not all properties of the debtors are transferred. Payment by cession, all properties of the debtor are transferred. The shonen payment, not all properties of the debtor is not insolvent. Payment by cession, debtor is insolvent, and the shonen payment, debtor's obligation is extinguished. Payment by cession, debtor is released from liability up to the extent of the proceeds of sale. Efficiency of insolvency or bankruptcy on the extinguishment of obligation. The purpose of Insolvency Act number 1956 as amended, is to bring about an equitable distribution of the insolvent's assets among its creditors, and to enable him to begin his commercial and social life anew with exempt property remaining with him. Although treated as identical, bankruptcy law and insolvency law differs from each other in following manner. Bankruptcy law applies to traders or merchants, while insolvency law applies to traders and non-traders. Bankruptcy law absolutely exonerates an honest debtor, while insolvency law may or may not exonerate a debtor from future liability. Under the insolvency law, a debtor is permitted to ask for suspension or postponement of payment of his debts if he foresees an impossibility of meeting these obligations as they fall due, or ask for discharge from his debts and liabilities by involuntary or involuntary proceedings. The distinctions between suspension of payment and insolvency are: suspension of payment, debtor has sufficient property to pay his debts. Insolvency, debtor assets are insufficient to pay his liabilities. Suspension of payment designed to delay payments, and insolvency designed to secure complete discharge from liabilities. Suspension of payment amounts to debts are immaterial. So insolvency, creditors receive less than their claims, and in cases where preferences are proper, some creditors receive nothing at all. The distinctions between involuntary and voluntary insolvency. Voluntary insolvency, insolvent debtor is the petitioner. Involuntary insolvency, three or more creditors are petitioners. Voluntary insolvency, residence of creditors is immaterial. Involuntary insolvency, creditors must be Philippine residents whose credit accrued in the Philippines, and none of them is a creditor by assignment 30 days prior to the filing of petition. Voluntary insolvency, debtor must not be guilty of acts of insolvency. Involuntary insolvency, debtor is guilty of any of the acts of insolvency. Voluntary insolvency, debts must be more 1,000. Involuntary insolvency, debts must be 1,000 or more. In voluntary insolvency, bond is not required. Involuntary insolvency, bond is required. The acts of insolvency that may be committed by a debtor are: intention to depart or actual departure from the Philippines to defraud the creditors, concealing himself to avoid legal process, absenting from the Philippines to defraud his creditors, concealing or removing any of his property to avoid attachment, suffering his property to remain under attachment for 3 days to defraud creditors, confession of judgment in favor of any creditor to defraud other creditor, suffering judgment by default to defraud other creditors, suffering his property to be taken legal process to defraud other creditors, making assignments, conveyance, or transfers in fraud of creditors, making transfers, conveyance, or assignments in contemplation of insolvency, failure of a merchant or tradesman to pay his current obligation for a period of 30 days, failure of a person occupying a fiduciary position or depositary to pay the money deposited upon demand for a period of 30 days, insufficiency of property subject to execution to satisfy judgment. Application of payment is a designation of a debt to which payment should be applied when a debtor has several debts of the same kind in favor of same creditor. Its requisites are: there must be one debtor and one creditor. There must be two or more debts of the same kind. The debts to which the payment is applied must be due, and the payment is not adequate to cover all the debts. Tender of payment and consignation. Tender of payment is the offer of payment made by the debtor to the creditor, coupled with a demand that the creditor accept the same. To be valid, it must comply with the rules on payment. Consignation refers to deposit of a thing due in competent court when the creditor refuses to accept without just cause the payment validly offered by the debtor. As a general rule, the debtor must first make a valid tender of payment before he can file consignation in court. However, consignation may be made without tender of payment in the following cases: when two or more persons claim the same right to collection, when the creditor refuses to issue a receipt, when the creditor is already incapacitated at the time of payment, when the creditor is absent or unknown or does not appear at the place of payment, when the title of the obligation has been lost. If properly made, the expenses of consignation shall be charged against the creditor. Loss of the thing due. A thing is considered lost when it perishes, goes out of commerce, or disappears in such a way that its existence is unknown or it can no longer be recovered. Only specific or determinate things can be lost. If the specific thing is lost without debtor's fault or due to fortuitous event, the obligation is extinguished except when it is stipulated with the law provides when the nature of obligation requires an assumption of risk. Under the law, even if the loss of the thing is not the debtor's fault or due to fortuitous event, he shall be liable therefore in following cases: when he is already in delay. The obligation of D is to give his only cell phone to C on June 1, 2006. On the maturity date, C demanded for the delivery of the cell phone, but D failed to deliver it. On June 7, 2006, while D was already in his way to deliver the cell phone to C, his cell phone was snatched from him. D is still liable for his loss because he is already in delay. When he made several promises of one thing to several persons having different interests, D sold his cell phone to X, who paid its price, then agreed that his cell phone will be delivered to X on June 5, 2006. D sold the same cell phone again to Y, who also paid its price with agreement that it will be delivered to Y on June 5, 2006. On June 2, 2006, the cell phone of D was taken by a snatcher. D is liable for its loss to X and Y, even if the cell phone was lost due to fortuitous event. When a thing lost is a proceed of criminal offense, D carnapped the car of C. D was arrested and convicted for the crime committed, and the court ordered him to return to the car to C not later than June 1, 2006. On May 27, 2006, the car was hit by lightning and was totally destroyed. D is liable for the loss of the car due to fortuitous event because the car is the proceeds of a crime. As of an exception to this rule, if D offered to return to the car to C as ordered by the court, but C refused to accept it without just cause, and the car was subsequently destroyed due to fortuitous event, D's obligation is extinguished. Condonation or remission of debt. It is a renunciation or waiver of the creditor's right to collect payment. It is essentially gratuitous and may be expressed or implied. The cancellation of the promissory note or the return of the check to the debtor are examples of implied remission. The legacy of 10,000 given by the creditor to the debtor who owes him the same amount is an example of express remission. Confusion or merger of rights is an extinguishment of the obligation whereby one person becomes the debtor and creditor of one and the same obligation. M issued a promissory note valued of 10,000 payable to P or order on June 24, 2006. P negotiated the instrument to A, and then it was negotiated to B, to C, and to D. On June 24, 2006, D negotiated a note back to M. Here, M's debtor becomes the creditor of the same obligation, and therefore his obligation to himself is extinguished. Compensation takes place when two persons in their own rights are creditors and debtors of each other. It may be legal or voluntary. It may total or partial. The requisites of legal compensations are: each of the obligors are principally bound. Both debts are in money or things are in the same kind and quality, if stated. Both debts are due and demandable. There is no controversy over the debts commenced by third persons. For example, D owes 20,000 in favor of C, payable on June 17, 2006. C is the obligation payable to D amounting to 20,000 payable also on June 17, 2006. On a maturity date, both debts are extinguished totally by operation of law even if they are not aware of it. If the obligation of C to D amounts only 15,000, the legal compensation is partial and C can collect 5,000 from D. If one of the debts is not yet due and demandable, the parties may agree its compensation with others' obligation, which is already due. This is called voluntary or conventional compensation. There can be no compensation when one of the obligations arises from deposit, comodatum, support, civil liability arising from crime or delict. Example: M deposited his only car, Toyota car model 2000 to N for 1 week or until May 3, 2006. M has an obligation to give Toyota car model 2000 N to May 3, 2006. The obligation of M to give car to N and the obligation of N to return the car to M cannot be compensated because one of the obligations arises from deposit. Next example. B borrowed a car of L, Mitsubishi Lancer model 2001, for 1 month until May 7, 2006. L has an obligation to give a Mitsubishi Lancer model 2001 to B on May 7, 2006. The obligation of B to return the car of L and the obligation of L to give Mitsubishi Lancer model 2011 to B cannot be compensated because one of the obligation arises from comodatum. The obligation of F is to give a monthly support of 1,000 to S every first day of the month. On April 1, 2006, S received 1,000 from F as his support for April 1, 2006. On April 15, 2006, S obtained a loan from F amounting to 1,000 payable on May 1, 2006. On May 1, 2006, the obligation of F to give the monthly support to S and obligation of S to pay a loan of 1,000 to F cannot be compensated because one of the obligations arises from duty to give support. X obtained a loan from Y amounting to 20,000 payable on December 31, 2005. Subsequently, they quarreled and X filed a criminal case against Y for serious physical injury. Y was convicted and he was ordered to pay X the amount of 20,000 as civil liability. X and Y cannot compensate their respective obligation because one of the obligation is a civil liability arising from delict or crime. Novation. Novation is a change of obligation by another resulting in extinguishment. It may be changed or modified by changing the object or principal condition, by substitution, change of debtor, by subrogation, change of creditor. It may be real or personal. Real novation is a change of object of principal obligation, while personal novation is a change of the debtor or creditor by another. The change of creditor is called subrogation. The change of debtor is called substitution. Substitution requires the consent of the creditor, but it may be made without the knowledge or against the will of original debtor, ex promission, or it may be with his consent, delegation. Once a substitution has been made, the creditor can no longer revive his action against the original debtor, and a substitute will subsequently become insolvent. This is because the obligation of the original debtor is already extinguished. However, in case of delegation, substitution with the original debtor's knowledge and consent, if the person substituted to the debtor's obligation is already insolvent or his insolvency is of public knowledge at the time of delegation, the creditor can revive his action against the original debtor. The person who is paid the obligation of the original debtor is entitled to reimbursement from the latter unless he waives the right to collect. But if the third person paid the debtor's obligation without the latter's knowledge or consent or against his will, the payer can only demand the reimbursement to the extent of the amount beneficial to the debtor.